Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of our show. Today, we are talking to attorney Dilair Nafoosi. Dilair, welcome to the show. Dilair has its own practice, which is called Lionheart Legal. I love the name. He practices in the area of trust and probate litigation, as well as conservatorship, guardianship, and as estate planning. It's a pleasure to have you. Thank you for doing this, Dilair.
Thank you for inviting me on, Matias.
Let's delve right into our subject matter, which is today we're going to be discussing something very important, which is trust and probate litigation. My first question to you, I guess, is what difference are there between the probate court and the court that other people, that we are more familiar with in movie and television, like civil or criminal court?
So within any county, we're talking about state courts because all probate matters go through state courts as opposed to federal courts. Within the state courts, you have different departments that handle each sort of case. So you have departments that handle only criminal matters, as you alluded to. You have departments that handle what's called civil matters. This is things you would think of like a business dispute or a breach of contract. You have family courts, which handle custody and divorce proceedings. And then you have probate courts. So probate courts, they have their own dedicated departments. They have their own set of rules and procedures. They have their own judges. They have some overlap as well with the other courts, but they do have their specific rules. So as a probate litigator, I need to be familiar with the body of law that governs probate, known as the California Probate Code.
Right.
When it comes to litigation, I also need to be familiar with the body of law called the California Evidence Code, which determines what sort of evidence gets heard in a evidentiary hearing or in a trial. I need to be in the procedure, which is governed by the probate code when there's specific rules that I need to know, but it's also governed when it's silent on a specific topic. It's governed by what's called the California Code of Civil Procedure. That applies to civil cases as well as probate cases when the probate code is silent on a specific issue. So for example, if you're bringing a motion in a probate matter, the procedural rules that must be followed are in the Code of Civil Procedure because there are not a specific set of rules for motions in the probate code. However, for probate hearings, there are things called probate notes. That is all very specific to probate, and you don't find these things in civil courts. I've been in the interesting position of having an opposing counsel who is a civil attorney. They don't really know about probate, and the judge has asked them during the hearing in front of everyone, hey, I didn't see a supplement to clear these probate notes. And the civil attorney's like, the probate notes, Your Honor? What are you talking about? And the judges had to print it out for them and give it to them during the hearing. But yeah, there are some specific procedures that are only applicable to probate courts that, if you are having an attorney, whether it's an administrative matter and there's no litigation or whether there is litigation, that experienced probate litigator is going to understand, and not necessarily every single attorney.
I appreciate your answer. Thank you. And let's pick up on a few things that you said. Well, one of the things that I wanted to talk to you about is probate notes. People talk about that. Every time I do a confirmation hearing on the sales side of real estate, there's obviously, it doesn't, there's a sometimes you're not first in line, so there's a court calendar, you get to sit in the courtroom and listen to a lot of, and people talk about probate notes. We need to clear the probate notes. There's this probate note to clear. So let's talk about the probate notes and the function that they have from a litigation perspective, let's say, or actually as you are getting ready to embark in litigation. What do you use the probate notes for?
Yeah, so I mean, the probate notes are basically a list. So prior to the hearing in LA County, it's maybe a week or two prior. It's closer to a week. In less populous counties, it could be a little longer lead time than that, over a week before the hearing. There will be a probate attorney who is on staff with the court who will review your paperwork relevant to the hearing that day, that morning, and identify any questions that they may have, as well as any deficiencies in your paperwork. Now, if you have an attorney who's competent and experienced and knows what they're doing, the probate notes and a person as a consumer checking their attorney's work and seeing, if they're trustworthy or if they're competent, if they know how to access those and find those, there's usually a way for anybody to do that. But, if you have like 10 or 20 probate notes, then that's a really bad sign that your attorney probably doesn't know what they're doing. And if your attorney does know what they're doing, you might either have no probate notes or you'll just have a few, 3, 4 maximum. If it's a very complex issue and there's a lot of questions, you can't do anything about that, but you might get more. But generally, you're not going to get too much more than that in the vast majority of hearings. It's funny you bring up court confirmation. I've seen plenty of hearings. The two most common probate notes you get in a court confirmation hearing are about publication. So when it comes to court confirmation, the publication needs to be done before the petition is filed.
Of course.
In pretty much every other instance in probate, you file first and then you give notice. But when it comes to court confirmation, you do the notice first, then you file. But the notice in this case is publication. The second most common probate note that will kill a sale or a court confirmation hearing is providing notice to the buyers. That is a little easier to remedy because the buyers can always sign what's called a notice waiver, and that can be submitted before the hearing. But you want to just give them notice in due course and ahead of time, because there's no way to cure that if they don't sign a notice waiver, and there's no way to cure the publication. Your petition's dead and you have to start over. So that's two things. Going back to the original question, another important distinction between probate courts and other courts, and what people see on TV, especially in this sort of stuff, is 99% of cases in probate court, the trier of fact is the judge as opposed to a jury. In civil cases, everyone's entitled to request a jury trial. In probate court, there's a very small sliver of matters that a person can request a jury trial for. So most of the time, the jury doesn't decide your probate case. It's going to be that judge. And again, getting an experienced litigator, someone who's local to the area or practices regularly in those counties, they're going to have a relationship with that judge, or the judge is at least going to recognize them, say, I've seen this person, I know they're honest. Hopefully they have a good reputation with the judge, and the judge has been around long enough to know who knows what they're doing. So does that answer your questions on the notes?
Yeah, absolutely. That does answer my question. And actually, it's great because we do a little segue into what I wanted to talk about next. So no voir dire most of the time in, no jury selection, et cetera, that people are used to. You do what is known as a bench trial. I guess in probate, it's just a trial because, you have just the judge. So, which brings me to essentially litigation strategies. You already talked about them. You already gave me some good, some very good information. These are the judges. chances are, if you litigate in Los Angeles County, you know all the judges that are sitting on the probate bench, because they're there. And I see it even with the confirmation hearings for the sale of real estate. You went, oh, you're in Department 79, oh, Department 2. Yeah, who's sitting in those departments. So talk to me about your litigation strategies, and then I will also ask you, what is that sliver of cases that I'm fascinated that do require that, where you can request the jury. So let's first talk about litigation strategies. Well, how does it change from other forms of litigation, do you think?
So just in general, there's just a few general concepts that I found to be extremely effective. I don't know, a good chunk of my cases are people who have hired an attorney. The attorney has not been doing a good job.
Mhm.
They fired them and they've hired me because they've been dissatisfied with what their other attorney's done. And a lot of this just goes to the basic skills that any attorney should have, clearly communication, especially writing.
Right.
You mentioned sitting in at court confirmation probate hearings for sale of real property and having to sit through an 8:30 a.m. morning calendar with maybe 20 or other 30 cases on that 8:30 calendar that morning. Well, the judge is sitting there. He has 20 or 30 cases. One of them is yours, but the other 19 to 29 cases are not. And I mean, how much time do you think he has to sit and read everything?
Right.
So one thing that I found to be effective is whatever the heart of the issue is and whatever your strongest argument is, have that in the first page or two of your pleading, of your petition, of your objections, whatever the pleading is. The pleading is the first document that gets filed. In civil cases, it's called a complaint. In probate cases, it's called a petition. And the response is called the answer in civil cases, or in probate cases, it's called either the objections or the response. Generally, it's called the objections. If I'm drafting a petition or objections, and I've seen this with these situations where somebody comes to me from their attorney who they're dissatisfied with, I read whatever petition this other attorney filed, and it's like, it's all boilerplate, boring stuff that this is the person, they died on this day. It's like, you're in litigation, dude. You want to have all the juicy, interesting stuff in the first sentence or two of the pleading you're filing, or you want to have the strongest evidence, like if you're doing the objection, this petition is totally false and misleading because this is community property, not separate property. Here, Exhibit A, this is the document that shows it's community property, or whatever the case may be. That needs to be all the way at the top. So that's just a great general strategy. It's not necessarily specific to probate, but yeah, put your best stuff up at the beginning. If the judge has to go to page 8 or page 9 of your filing papers to get to the heart of the issue or the heart of your argument, they're not going to be focused on it at that point. I mean, you've bored them to death. Judges are just human beings, just like you and me. I mean, if you give them something interesting to read, something clear and concise, that's another thing. Another thing, clients tell me all the time, okay, this is great. I really like this. Why don't you mention this little thing that, they were mean to me and they've been rude and they cussed me out this way? I'm like, it doesn't matter. The other thing you get an attorney for to win your case, to advocate for you, is because the attorney knows what the law is. And the law isn't written, if they're mean, they get less of an inheritance, or you get to remove them as trustee. No, that's not what's called the elements of the case. If you have a case to prove, you have to prove A, B, and C. It's spelled out in what the law is. Focus your discovery, what you're targeting, the evidence you're going for, the questions that you're making the other side answer. Focus on either proving those elements or disproving the elements, depending on what side of the case you're on, you need to focus on that because that's what the judge is going to look at. The judge isn't going to look at how they're nasty or whatever. The judge is going to say, is there a breach? What's the breach? Show me the breach. Show me the bank statement that shows the breach. Show me the wire. Show me if you're saying they spent way too much on this particular thing, show me the reasonable cost of services that's normally charged, right? Show me the self-dealing. This is the important stuff. And that's why attorneys, my job is often to sit and tell the client, I say, look, this is not a good use of your time to mention this or go down this road. We already have this evidence. This is the strong evidence. This is going to win your case, or this is your most compelling argument. Let's focus on that. And maybe I'll mention this at the very end when the judge is ready to move on to the next thing he has to read for the 8:30 calendar that morning. But we're not going to focus on that. So it's just a matter of dealing with the evidence you have. Another thing that I think is unique to the probate bar, as opposed to and by probate bar I mean attorneys who practice primarily in probate law versus civil attorneys. I mean, part of the strategy is kind of can be, especially with the less ethical attorneys, is just running up fees and costs, and that can be a strategy. We're not supposed to do that. We took an oath when we get our license to not use those sorts of tactics, but it's very, very common in civil. And I can recognize someone who doesn't practice probate law if they're an opposing counsel very easily, because they resort to these sorts of tactics. They like to puff up their chest and be very adversarial and try to make it personal. And there are some probate attorneys who do that too. But in general, there's more civility and etiquette. And I think the reason for that is not because probate attorneys are necessarily better or worse people than civil attorneys, but I think the reason is any experienced probate attorney knows, depending on the situation, but really at any time, someone can look at our billing statement. Maybe the court looks at our billing statement. Maybe our fees are not subject to court approval, but at some point during the litigation, they become subject to court approval. And now we have to justify everything we've done. And so I understand that as a probate attorney. And so I'm not going to waste my client's time or money going down a road that's not really productive. I'm going to be as civil as possible and try to minimize the conflicts, because I think 99% of the time, over 90% of the time, the fight is not over millions and millions of dollars. When the typical person dies in LA County, they're going to own a house. They're going to maybe own some retirement cash account securities, but it's usually not tens of millions of dollars, maybe tens of millions of dollars. It's worth the fight if one side's at 0 and one side's at 100%. But for the vast majority of families that are passing down wealth, it's usually a house. It's usually, assets that are less than the value of the house. And it's usually split between two, three, four people. And so you have to take all that into account and do a cost benefit analysis. Do you want to spend $200,000 going to trial, each side, expert witnesses and things like that, depending on the issues involved, on top of those legal fees and costs? Probably not. Probably it's not going to net you. In California and most state jurisdictions as well, you have what's called the American rule of attorney's fees, meaning you pay your own attorney's fees and they pay their own attorney's fees. There's no fee shifting, loser pays or anything like that. And even if there is, sometimes you have a judgment proof opponent or somebody who's going to hide their assets or make it difficult for you to enforce a judgment. So it's often not, from an objective standpoint, fruitful for the client to get involved in disputes that can be avoided through reasonable negotiation. So that, I think, just that in general, just being reasonable, being open, explaining to your client, look, we can go down this road. this is how much it's going to probably cost, but you have this other option that's less costly, but it's going to require a little negotiation, but it will work out for you in the end, I think, because of A, B, and C. And just having that relationship where you're with your client, where you can really discuss these things, and there's a level of trust on you as their advisor, so they can kind of go with your recommendations, and that's going to work out for them and be beneficial for them and net them more of what they want at the end of the day.
Thank you. Thank you for sharing that. Dilair, I love talking to you. I mean, you that makes total sense. Put the juicy stuff at the beginning, right? But your
Absolutely.
point, and I agree with you 100%. I see this even in my business. You know, what is the important stuff? Because clients sometimes get lost, and we do too, like, oh, that person did this to me, this other person did that to me. It's like, you know what? The important thing is, like, you are absolutely right. What is the breach? What is the issue? Show what the issue is, and then that's what you focus on, not because somebody yelled at you or called you names or whatever.
Right. Matias, I have seen people waste thousands and thousands of dollars, blow up $1 million settlement deals and, plus over old china, over a chandelier that was appraised at $500. I mean, I've seen some ridiculous stuff. Photos, old photos, I mean, and just thousands and thousands of dollars over this stuff. And you know what? It's fine if I have a client that's really important, it's important to them too. It's totally fine. I just want them to know up front, you are going to be spending this much money on this thing. If it's really important to you, you're the client, you get to pick what you want to do. It's your money. But don't get mad at me when you get the bill if what you get at the end is not worth what you put in. And for me, of course, all my clients are great. They're all very reasonable people. It's never my side, right? That focuses on this stuff. It's always the other side that's unreasonable. But yeah, I mean, you see it. So, but yeah, absolutely. As long as the client's making an informed decision, they could do what they want. But yeah, absolutely. It's like chess. You have to see 2 or 3 steps ahead of time, because if you get to the end and your client doesn't know what they're getting into, they're going to be upset with you. And you don't want that as an attorney. You want to have explained everything to them ahead of time so they can make an informed decision. That's a huge part of my job.
Thank you very much for that. I mean, I could talk to you for hours, but now let's talk about your journey, because I'm interested. What made you decide to become an attorney?
Well, I did not know I was going to get into law. My father is a physician, and I thought I was going to be a surgeon as a child. And then I took biology in 9th grade, and I'm like, oh, these words are so long, and you have to memorize all these parts. So I found out, biology, getting into that wasn't really something that I was super interested in. I applied for colleges for engineering programs and for business. And all the engineering places I applied for didn't accept me. All the business programs I applied for accepted me. So I feel like they kind of made that decision for me. After business school, I graduated in 2010. This was just after the great financial crisis of 2008. I went to college in the East Coast. I got an offer to work at a large investment bank in New York City. However, I'm from Southern California. I was born in Southern California. I was raised in Southern California. I've been here all my life. I did not really enjoy the winters in the East Coast. And I didn't know anyone in New York City. And I was like, man, that's going to be a tough city to just start fresh and not knowing anyone. So I declined that. I wanted to look for work in Southern California. I came back to Southern California, and I interviewed with 3 CEOs, and they all basically told me, "Oh boy, you picked a bad time to graduate." So so it's difficult. I had a family friend who contacted me, heard I graduated recently. He said, I know you're very good at math. I got perfect scores on my math SATs twice. And he said, I think you'd be a really good poker player. And I said, well, I don't know anything about poker, and he's like, well, would you do an internship with me? I'll teach you how to play. And I said, does it pay anything? He goes, well, look, I'll teach you how to play. You'll meet me. I'll finance everything. If we make any money, I will split the winnings with you. I said, well, that beats, being unemployed. So I agreed to it. He sent me a pile of books, about this many books. He said, read all the sections about No Limit Texas Hold'em and meet me in Las Vegas in a month. So I did that. And I was a professional poker player for about 3 months. And it was great because we were making like $2,000 a week each. We were playing 8 hours a day, 5 days a week. And it was great because we got really confident towards the end of that, and we started playing in the higher stakes games. And those guys were sharks, and, and we were like, okay, we'll stick to the lower stakes. But the more advanced, the higher the money gets, the better the players are, and the more familiar they are. But he suffered from multiple sclerosis, so it was difficult for him to live out of a hotel room. So he had to go home. He went back to Arizona, my coach and mentor in poker. And I had to make a decision at that point. I said, and whether I was going to continue and do this on my own, with staking my own funds, or, figuring something out. So at that time, I had a close family member, and they basically lost a house. It was like very unfair circumstances. And I thought in my mind at the time, I thought, if I was a lawyer, if I knew the law, I could have prevented this from happening. And that kind of got me down the road of going into law school and stuff. So it was kind of a complete surprise to me. And it was a decision I made in my early 20s and not before. Once I got into law school. I got a nice scholarship. My alma mater is Pepperdine University. That's the school of law I went to. And it was great being in Pepperdine. It was a totally uplifting and great experience. Not as much as my undergrad, I can't say that about, but it was a great time. And then I started working before I got my bar results, a month or two. I passed the first time, and the first firm I was working at was a probate firm, and they kept assigning me to litigation cases. I had one particularly very litigious, kind of larger conservatorship litigation matter between two sisters who really didn't get along. I represented one sister, and I got the other sister removed as co-conservator. She fired her attorney immediately, the other sister, after I did that, and then hired a more high-powered, aggressive attorney. And I just learned a lot in that process, dealing with very aggressive litigation and a fight in a conservatorship. And I did well, and my client was really happy with me. And I just figured, I guess I'm good at this, and I'll just stick to it, So that was in 2014, 2015, and I worked for firms for a couple of years. I started my own firm in 2016, and just been kind of sticking to this since. And it's good. You help people get through a difficult time.
That's great. Such a wonderful story. I love the professional poker player turned attorney. Let me conclude with one of the things that I like to do. I have a list of questions. I want you to pick a random number between 1 and 30, and I will ask you that question.
28.
If you could be invisible for a day, what would you do?
Invisible.
Yes.
Oh boy, I don't know. This is a wild question.
You want to pick a different number? You can have another choice if you want.
Okay, 18. Let's do 18 instead.
18. All right. What was your first paying job?
First paying job. Okay, this is easier. I still can't. I'm still like trying to think. Okay, my first paying job was I worked in high school. I think it was either the summer after sophomore or junior year. But I lived, hopefully your audience and you are familiar with the Southern California area. I was in Glendale. That's where I lived. with my father. And my first job was at a payday loans in Redlands.
Oh, wow.
And I just got my driving permit and my driver's license. So I was so happy to drive at the time, but I would commute,
Wow.
like 60 miles to work and back. And I did that in the summers. And I was like the customer service representative at the payday loans place. So that was a very interesting job, but that was my first paying job. Yeah.
That's awesome. That's awesome. Okay, before I let you go, we're gonna have your contact information in our show notes.
Oh,
For the
great.
people who are listening, what is the best way to get a hold of you? How do you do the client intake process, basically?
Yeah, that'd be great. So Lionheart Legal is my firm. I'm the owner. Our motto is compassionate, quality, cost-effective service. We know when you're calling us, you're going through a difficult time, whether it is just getting through the probate process and navigating it, or because a loved one just died, or you're the successor trustee of your parents' trust or a loved one's trust, and you have no idea what to do or how to do it. Or you're in a fight of some kind regarding these sorts of affairs, or in the conservatorship case, you're dealing with an aging parent or aging loved one, and they're being taken advantage of, or they need help managing their affairs and they're not accepting help. What do you do? Well, you need someone who can help you technically and understands that. But, it's a difficult time, and I understand that. The people we work with at my firm, we all understand that. And we're not going to treat you just mechanically. We understand there's an emotional aspect to it, and we're sensitive to that. So that's the compassionate side. The quality side is, we're not going to type a 10-page document and have the good stuff at the end, right? We're going to deliver a quality product. We're not going to bring petitions and stuff frivolously when we know they have no chance of getting granted. Or if we're going to do it, we're not going to do it day one and just to get it in. If there's no chance it's going to get granted, we're going to take our time, gather our evidence, give you the strongest possible case to get granted. Because at the end of the day, you want to win. You want to get those court orders, right? So it's gonna help you to spend a few extra days or few extra time to make sure you're giving the court a quality pleading, a quality paper, get that in. And then finally, cost effective. I don't charge the least. I don't charge the most. I think I charge market price. It's fair, but we don't waste our time. You're paying for someone who gets done things in a reasonable amount of time. It's not going to waste your money on going down roads that aren't going to be fruitful for you. So that's our motto. Our website is lionheartlegal.com. It has all my contact information. You can call us, you can email us, and we offer free consultations to see if it's a good fit, or if you even need an attorney. I can't tell you how many times I've talked people out of hiring me because it's just a waste of their money. It might not necessarily be something that they need to hire an attorney for. It can be something that can be solved some other way, or the stakes aren't high enough to justify the attorney's fees. That's a decision every individual makes, but again, it needs to be their informed decision. So I'd be happy to talk to anybody kind of going through these things or needs help or guidance in these things. And again, the best way to reach me is through my website, lionheartlegal.com. It will have all the contact information, more information about me, our firm, and our practice areas.
Thank you so much. It's been such a pleasure to have you on the show. Thank you, everybody, for joining us, and we will see you on the next episode. Bye.
Bye. Thank you, Matias.
Thank you.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The probate realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547663. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.